Hello, everyone, and welcome back to part 8 of Polity Premier League 2025. Let's begin. First question. Which of the following statements are correct? Number of judges in the Supreme Court can be increased by the Parliament, whereas number of judges in the High Court can be increased by the President. So, of course, this statement is correct. In case you want to increase the number of judges, you have a parliamentary law. And what is that law? Supreme Court Number of Judges Act 1956. You modify the law, amend it, and you can then increase the number of judges. Like the last time in 2019, this law was modified and the number of judges was increased from 30 to 33 plus one Chief Justice of India. Okay. And as far as High Court judges are concerned, they are increased by an executive order, like we recently increased the number to 1,122 judges. Number two, impeachment process of judge of Supreme Court and High Court is the same. Yes, this is exactly the same process of removal which is required for removal of High Court as well as Supreme Court judges. Salaries, allowances, and pensions of judges of both Supreme Court and High Courts are charged in the CFI. This is a wrong statement. The salaries of Supreme Court judges, allowances of Supreme Court judges, and the pension of both Supreme Court and the High Court judges are charged on CFI. But the salary and allowances of High Court judges, it is charged on CFS, the Consolidated Fund of the State. So 3 is incorrect. The advisory jurisdiction of Supreme Court has to be presided over by minimum how many judges? Of course, 5 judges. This is mentioned under Article 145, Clause 3. So 1, 2, and 4 is the right answer, C. Next question. Consider the following. Assertion. Capital punishment passed by a trial court cannot be executed without the concurrence of the Supreme Court. Number 2, or reason. India has a pyramidal integrated judicial structure that provides for control of the High Court over the subordinate one. Now, as far as these kind of questions are concerned, assertion, reason-based questions, statement 1, statement 2 based questions. Now, in this situation, what exactly is going to happen? In almost every case so far in UPSC Prelims, especially for polity, I can speak for polity, we have always found that in such questions, either assertion or statement 1 is wrong, or reason or statement 2 is wrong. And the answer inadvertently ends up being C or D, right? So the first target should be to eliminate one of the statements. Now, in this case, the assertion statement is wrong because capital punishment passed by a trial court, meaning a lower court, a subordinate court, cannot be executed without the concurrence of the High Court and not the Supreme Court. So since assertion is wrong, this means A is wrong, A is wrong, A is wrong. Right answer is D. A is incorrect, R is correct. Yes, we follow an integrated judicial structure in the country. Next question. Arrange the following courts in a state in decreasing order of their hierarchy. So, decreasing order of hierarchy means what? In this situation, we'll have to arrange the topmost court and then move on to the lowest in the order of hierarchy or precedence, starting with, of course, the High Court. High Court is the senior-most court. And then we have the Sessions Court. Then we have the Court of Subordinate Judge. And finally, the Munsif Court. So 1, 3, 4, and 2. 1, 3, 4, and 2. B is the right answer. Next question. Which of the following statements regarding judges of Supreme Court is incorrect? The senior-most judge of the Supreme Court should be appointed to the office of CJI is actually correct. It is mandatory for the President to consult Chief Justice of India during appointment of other Supreme Court judges. Mandatory to consult CJI is also correct. Number 3, the Constitution has prescribed 45 years as the minimum age for appointment as a judge of Supreme Court. Though this is actually a very interesting convention, though it has been broken on certain occasions. For example, Justice D.Y. Chandrachud became a judge in the Allahabad High Court at the age of 39. It's a very popular convention, but it is not mentioned in the Constitution. Hence, this is the right answer. And D, only a citizen of India is eligible to become a judge of the Supreme Court. Absolutely correct. Right answer C. Moving on to the next question. Which of the following statements is or are correct? Judges of Supreme Court can be removed only on the grounds of proved misbehavior or incapacity. Yes, that is the only ground mentioned in the Constitution under Article 124, a very important article. Please go through this article whenever you are revising the topic Indian judiciary. Second one, the Speaker or Chairman of the House has discretion to admit or reject the motion of removal of Supreme Court judge. The Speaker or the Chairman of the House, of course, has complete discretion on whether he wants to admit the motion for removal or reject it, like in the case of Justice Deepak Mishra. When the motion was raised in the Rajya Sabha, the then VP or the chairperson, Venkaiah Naidu, rejected the motion for the removal. So, 2 is also correct. Right answer is C. Next question. Which of the following statements is or are correct regarding the composition of High Court? Every High Court consists of a Chief Justice and such other judges as the Governor of the concerned state may from time to time deem necessary to appoint. C. Every High Court consists of course, Chief Justice and such other judges as the Governor. Sadly, the President is the one who appoints the judges of the High Courts as well as Supreme Court, though, of course, in consultation with the Governor. So, 1 is wrong. Second one, the Constitution does not specify the strength of a High Court and leaves it to the discretion of the President. This is absolutely correct. Hence, right answer is B2 only. Next question. Consider the following pairs regarding provisions of High Court judges. Second Judges Case 1993. No appointment of a judge of the High Court can be made unless effective consultation with a collegium of judges is done. Absolutely correct. This is the case where we started, where it all began. The concept, the idea of what? The idea of a collegium system, which has been constantly under heavy criticism. Second one, Third Judges Case 1998. The Chief Justice of India should consult a collegium of 2 senior-most judges of the Supreme Court. Yes, when it comes to High Court judges appointment, you must consult 2 senior-most judges. When it comes to Supreme Court judges appointment or recommendation, this collegium becomes 4 plus CJI, right? Anyway, so second one is also correct. Please write in the comment section when it comes to transfer of judges from one high court to another, what is the collegium or what does the collegium comprise of? Now, number 3, 99th Amendment Act, that's NJAC. So NJAC to make recommendations for appointment, for transfer and removal of judges of High Court. No, NJAC was of course established for making recommendations on appointment and transfer, but not for removal. The removal is done through voting in the parliament. So 3 is incorrect. Which of the pairs are matched correctly? A, 1 and 2 only are matched correctly. Next question. Which of the following statements are correct regarding the qualification of judges of a high court or judges of high courts? The Constitution has prescribed a minimum age for appointment. There is no minimum age prescribed. Though what is the maximum age or the age of retirement or superannuation? It is 62. It used to be 60. It was increased to 62 in the year 1963. Anyway, so 1 is wrong. He should have held a judicial office in the territory of India for 10 years. Yes, of course. He should have been an advocate of a high court or high courts in succession for 10 years. This is also correct. Both these are correct qualifications. Right answer is B, 2 and 3. Apart from this, if you talk about Supreme Court has a similar kind of qualification. You should be a judge in the High Court for 5 years, an advocate in the High Court for 10 years, and there is one more qualification with respect to Supreme Court judges. Please write in the comment section what is the qualification, the third one, which is required for you to be eligible to be appointed as a judge of the Supreme Court. Then the next question, which are the following, or which one of the following is directly related to the appellate jurisdiction of the Supreme Court of India? Appeals made in civil, criminal, and constitutional cases. So the right answer is this. Appellate jurisdiction with respect to civil matters, criminal matters, and of course, constitutional cases. These are provisions of Article 132, 133, and 134. Next question, with reference to advisory jurisdiction of Supreme Court, consider the following statements. The court may refuse to give its advice on any question of law or fact of public importance. Okay, advisory jurisdiction, article is 143. So yes, the court may refuse to give advice on any question of law or fact of public importance is correct. Supreme Court is bound to give advice on any dispute arising out of any pre-constitution, treaty, agreement, covenant, engagement, sanad. Sanad basically means a charter, right? That's the meaning of sanad. Or other similar instruments. Yes, in such cases, the Supreme Court shall give advice, is bound to give advice, cannot refuse. So 2 is also correct. Right answer is C. Moving on to the next question. Consider the following statements. There is no fixed tenure for Supreme Court judge, as he can be removed from his office by the President on the recommendation of the Parliament at any point of time. Yes, this is absolutely correct. Recommendation of Parliament here means what? It here means by a process of voting. What kind of voting? A special majority, which is 2/3 present and voting, or more than 50% of the total membership of the House, whichever is, of course, more. So 1 is right. Second one, the conduct of a Supreme Court judge cannot be discussed in the legislature except during impeachment motions is also correct. You cannot discuss the conduct of judges in the courts, of course, unless an impeachment motion is going on against them. What is the right answer? C, both 1 and 2. Next question. With reference to Indian judiciary, consider the following statements. The oath and affirmations for the Supreme Court judge is provided under second schedule of the Indian Constitution. So the oath and affirmation for the Supreme Court judges is mentioned in the schedules, but it is mentioned under Schedule 3 and not Schedule 2. So what is mentioned under Schedule 2? Under Schedule 2, you have the salary and emoluments mentioned. Second one, so this is wrong, of course. Second one, any retired judge of the Supreme Court of India can be called back to sit and act as a Supreme Court judge by the President with prior permission of the Chief Justice of India. Any retired judge of Supreme Court of India can be called back, of course, yes, to sit and act as Supreme Court judge, definitely, by the CJI with the prior permission of the President. It's exactly the opposite. This provision has been used a couple of times in the 1950s. So 2 is also wrong. Right answer is D, neither 1 nor 2. Next question. If the President wants to seek legal opinion on a matter of public importance from the Supreme Court, then Supreme Court can assume to itself the power of legislation. Of course not. Why would Supreme Court assume? No. Of course we know Supreme Court can. Use of Article 142. And Supreme Court tries to give itself a lot of powers, but let's not go there. Contempt of court can always be issued against us. Let's be safe. Supreme Court is amazing. It's the best. So A is wrong. The President has to accept the advice given by the court. No, the President or the government is not bound by the advice of the court. The Supreme Court may refuse to tender its opinion. Yes, of course, Supreme Court can refuse to tender its opinion when the President seeks opinion on matters of public importance. So C is the right answer. D, the President has to first get the approval of the Parliament for the same. No such provision exists or condition exists. Then we have the next question. Supreme Court is a court of record. Yes, Supreme Court is a court of record under the provision of Article 129. Also, High Courts are called court of records under the provision of Article 215. Means what? The judgments of Supreme Court are recorded for perpetual memory. Yes, they have evidentiary value. And number 2, the Supreme Court has the power to punish for contempt of court. Yes, Supreme Court being a court of record has the power to punish for its contempt. It also has the power to review its own decisions by virtue of being a court of record. These two powers also exist or are available to the high courts as well. 1 and 2 both are correct. C is the right answer. And then the next question, which is the last question for today. Consider the following statements regarding the removal of judges. The judge of High Court can be removed on the same ground as the judge of Supreme Court. Ground meaning reason. Yes, of course. The judge of High Court is removed on the same ground. Proved misbehavior or incapacity as a judge of Supreme Court. Violation of the Constitution is the only ground for the removal of the High Court judge. No, the ground for removal is proved misbehavior or incapacity. So 2 is wrong. Now please tell me in the comment section which person, or rather which is the dignitary for whom the ground for removal is violation of the Constitution. Mention the name as well as the article. That would be amazing. So here 1 is right, 2 is wrong. Right answer is A, 1 only. This brings us to an end of our discussion today. Let's meet in the next video. Till then, that is all for me. Jai Hind.